Welcome after a week of No America to Crossroads. It's great to be back. Janice can't be with us this evening, but she will be back next week. Tonight's program promises to be informative and current. The role of women in helping to rescue our democracy is as salient as the Dobbs decision and next month's midterm elections. I'm going to spend a moment to highlight some extraordinary programs we've scheduled over the next few weeks. Next week, we'll host the New York Times chief White House correspondent, Peter Baker, with Susan Glasser, the New Yorker's White House maven. They'll be discussing revelations from their bestseller, The Divider, Trump in the White House, 2017-2021. As the New York Times said in its review, it's all here. They'll be in dialogue with KCRW's Madeline Brand. The following week, we will host a much-needed examination of crime in America with two experts. William Bratton, former commissioner of the New York Police Department and former chief of the LAPD, together with Michael Moore, the present chief of the LAPD. They'll join the LA Times' Pat Morrison to discuss crime in America, myth versus reality. That'll be on October 26th. Given the allegations of a wave of crime engulfing us, they will offer data and the truth about what's actually happening. The following week, we have a newly scheduled program about which we are very excited. The illustrious documentarian Ken Burns and his co-producers will join Rabbi Sharon Brous to discuss lessons for today from the universally praised PBS series of last month, The U.S. and the Holocaust. It should be fascinating. And finally, on Tuesday after the elections, on November 15th, again a Tuesday, we're joining forces with NPR station KPCC to present a live and Zoom program, a combo, Democracy on the Brink, analyzing the election results with national and local experts, including NPR's Mara Liasson, Pulitzer Prize-winning columnist Clarence Page, and polling expert, The Atlantic's Ron Brownstein. The live event will be at the Skirball Center in West LA, and the entire 2-hour program will be webcast on Zoom for those who can't come to the center. You'll receive information tonight on how to register for attending, whether live or via Zoom. In-person attendance is limited, and reservations will be on a first-come, first-served basis. Look to the end of the email for the relevant links. And now to introduce tonight's dialogue, Zev Yaroslavsky, a founding member of the JDUDJ board. He's a decades-long leader in Southern California, having served as an LA City Councilman and LA Board of Supervisors member. He has been very busy this week responding to the crisis in LA local government that has made national headlines. Nevertheless, he's with us this evening to introduce our guests. Zev?
Thank you, David, and I'm delighted to be talking about something else. Our guest tonight is Dahlia Lithwick, a lawyer, writer, and journalist. Dahlia is a contributing editor at Newsweek and a senior editor at Slate. She primarily writes about law and politics in the United States. In 2018, the Sidney Hillman Foundation awarded her with the Hillman Prize for Opinion and Analysis Journalism. They noted that she, and I quote, has been the nation's best legal commentator for 2 decades, unquote. Dahlia's recent book, Lady Justice, Women, the Law, and the Battle to Save America, was acclaimed by the New York Times as both inspiring and stirring. Her writings have appeared in the New Republic, the American Prospect, the Washington Post, among many other publications. We are honored to have her with us. To engage her in conversation this evening is Professor Richard Hasen, an internationally recognized expert in election law and campaign finance regulation, now on the faculty of the UCLA School of Law and a colleague of mine at the UCLA campus. He also directs UCLA Law's Safeguarding Democracy project. Rick has been both a guest and an interlocutor on our America at a Crossroads program. He's widely recognized as a legal scholar, both in California and across the country. We are delighted to welcome him back. So Rick, it's all yours.
Well, thank you. Thank you, Zev. Thank you, David. It's great to be back with you. This is really a special pleasure for me. Dahlia Lithwick is a good friend who's interviewed me many times about my work, and I'm so glad to be able to turn the tables. And here's what I'm going to say. The first thing I'm going to say before I start asking questions, this book, buy it because it's 3 books in one, right? It is Profile of Women Lawyers Who Are Heroes. It's a look back at some of the worst moments of the Trump era, and it's kind of a personal memoir. And it's really, I was mentioning to Dahlia how I was surprised at how well she was able to weave all of these things together. I think it's a remarkable feat. And so Dahlia, I want to open up by talking about something that you said near the beginning of your book. I thought this project sounded great from the beginning, but you talk about a law professor. You don't say who, but you say it was a prominent constitutional law professor, so we know it wasn't me, who told you not to write a, quote, pink book about the law. So I thought I'd start by talking about what did you make of that comment and what it says about the state of thinking about women and the law generally? How did you come to write this book, and what kind of resistance do you feel that you faced?
So first of all, thank you to David. Thank you to Zev. Thanks to all of you who are Zooming in. And Rick Hasen slightly underestimates the nature of, not only have we been friends for a long time and co-conspirators on a lot of things for a long time, we've worked together in so many contexts, it's almost embarrassing, but he also, his fingerprints are all over this book. I think he might be one of the most cited kind of Where's Waldo characters in this project. And he appears not just in the sections on voting rights where you would expect it, but also in sections about MeToo and being a good ally. And so I just want to start by saying this is extra meaningful, not just because, you know, Rick, you've been a friend and a mentor, but because for reasons that will become manifest when we talk about that section, you really modeled for me what it is to show up for women. I think, you know, that the sort of flip answer on what it means to write a pink book about the law is, of course, the law itself is a pink book about the law. It's just that it was always written by men. There's no question that the law organizes and orders every single aspect of everyone's lives in this country, and that the Constitution and all of the framing documents, and in fact, the 14th Amendment, were all written with very much by men for men, without much understanding of the possibility that women were fully realized moral agents whose lives would be shaped by all of these laws and statutes, and yet women would have no input. And I know when we talk about Dobbs, we can talk about the ways in which, if you want to go back to that revanchist framing, you certainly can do that. So I think that my short answer, both to you and to the person who said, you know, you've built up 20 years of capital covering the Supreme Court, you know, people take you seriously. Why do you want to write a book about women in the law? My answer was very much, look, if a man had written a book about women in the law, it would be seen as a blue book about the law. It's funny the ways in which, if a woman writes it, it is almost by necessity something smaller. And so I wanted to really reclaim that. And I should just note, I fought very hard to have a bright pink cover for the same reason, because I think that for too long, women have acceded to the notion that the law is something that we have to fight our way into, claw our way into, make ourselves known and heard within the legal architecture of the country. And that's a kind of trivial or secondary project. And so I just figured, let's just stipulate that the law is itself a little pink book about women. It's just that it's time for women to write it too.
And when you wrote this book, you know, if you said you're writing a book about women in the law in the US, you might think it would be a lot about Justice Ginsburg or about Sandra Day O'Connor. You talk a little bit in the introduction about Polly Murray. And before you turn to contemporary, what I consider to be heroes fighting for rights in the United States now, why the contemporary focus? And you know, why did you start with Polly Murray before turning to Sally Yates?
I think part of the project here was to write a counter narrative that somewhat disrupts the idea that law for women in America begins and ends with RBG. And I think that we are so starved for heroes, and that makes an immense amount of sense to me. But I think the notion that RBG single-handedly devised, you know, gender equality under the 14th Amendment is wrong. By the way, the first person who would make that point in every interview was RBG. She was always at pains to say, I stand on the shoulders of so many women. And then she would name check Elizabeth Cady Stanton, and she would name check Polly Murray and a whole bunch of other women who did, I think, the toiling in the vineyards for centuries, sometimes without accolades. But I think maybe more existentially, Rick, I worry that this culture of hero worship, of hagiography, kind of gets in the way of our doing the work. And what I wanted to think about was, we spent, you and I included, spent 4 years of the Trump era and the 2 years after sort of doing the popcorn emoji, right? We're going to let Bob Mueller save us. Now we're going to let Merrick Garland save us. Here we go. I think if we just wait long enough, Jamie Raskin and Adam Schiff are going to save us, and we'll just watch. And what I wanted to press on a little bit, and I cite the amazing Rebecca Solnit in the introduction, who says that this kind of great man philosophy of American history and of American legal history is so wrong-headed, in that we get really, really obsessed with our heroes. And you can remember it was Fiona Hill one day. There's always someone, and then we all get the mug, and then we get the tote bag, and then we want to read the books. But I think lost in that narrative are two things. One is that's actually not how the work ever gets done. It's never one great man riding in, on a white horse with a white hat, saving it for all of us. And maybe think about de Tocqueville, maybe think about the smartest, observers of American history who say, no, this is the stuff that gets thrashed out in the marketplaces and the streets. That is the work of democracy. So I wanted to slightly subvert that, but I think more urgently, this is not how women do the work of democracy. And whenever, and you guys may remember when Ketanji Brown Jackson, was tapped for her seat at the Supreme Court, the first thing she said is, I stand on the shoulders of Constance Baker Motley, Black women who came before. And I think that if I'm right about the fundamental proposition that women have had to claw their way into the Constitution, into American legal history, then the women who get forgotten are much more interesting to me than the ones who are lifted up and reified. And so just very briefly, Polly Murray is an obsession of mine. If folks have not seen the documentary by Julie Cohen and Betsy West, My Name is Polly Murray, I think it is one of the most important films that I've seen in the last 10 years. And Polly Murray wrote what became the briefing in Brown v. Board, but never got credit for it. Wrote it as a law school paper in 1944. Thurgood Marshall and the Legal Defense Fund used the material as the spine of the Brown v. Board pleadings and never put her name on the brief. Polly Murray wrote what would become the spine of RBG's arguments about using the 14th Amendment for gender equality. RBG at least put Polly Murray's name on the brief, but I just think every single one of us lives in the slipstream of Polly Murray's version of what the 14th Amendment does, both for race and for gender. And all but a few of us have never heard of her. I never learned about Polly Murray in law school. So I think in a book that wanted to be about who gets famous and who gets credit and who is remembered and who does the work, and how democracy is a team sport in which huge numbers of people are forgotten, Polly Murray seemed like a really, really important and symbolic avatar of all of the ways in which women do the work, I think.
And it does seem then that it's appropriate that you went right from there into talking about Sally Yates. Sally Yates was a career DOJ person. She'd been standing up for the rule of law all of her life, but she, when it came to the question of the Trump travel ban, she had to do some extraordinary things against a president who had really intense and scary supporters. What do you think Yates's story tells us about how to react in the face of adversity? What does it tell us about standing up to lawlessness in the future? Because I think you and I are both worried that we've just been through, the latest round and not the last round of what we've seen in the last decade.
Maybe we should start from the proposition that there should have been thousands of Sally Yates. And one of the things that I note at the end of the chapter is that Sally Yates, who simply said, I cannot enforce this travel ban, she was only the acting AG. She was just kind of biding her time until Jeff Sessions was confirmed. She knew she was on the way out, and yet she found out about the travel ban the way we all did on our phones. Nobody vetted it with the DOJ, just got plunked on her. And she thought about it really carefully and said, I can't enforce this. I'm also not going to quit, because that too is a betrayal of all the attorneys, the line attorneys at Justice, who are going to have to go out and fight for this. And so she essentially said, I'm not going to quit. I'm going to simply say, I cannot in good conscience enforce this. I think it violates the religious protections of the First Amendment. I think it violates due process. So she did the thing that not a lot of people did, which is just wait to get fired after saying, I will not put the imprimatur of my DOJ on something that I think is lawless. And so to your question, Rick, it's heartbreaking that many, many more people who later would say, oh, I told Donald Trump he was doing something unlawful. But I sort of said it over dinner one time, and then I stayed in office and waited till get fired. And then I wrote a book about it and tried to cash in, and now I'm on TV. She did the opposite of that. And again, it goes to this hagiography and branding and fame point. She just let them fire her. And I think maybe I also started with Sally Yates because I wanted to start, first of all, with a white woman, because the book ends with another woman from Georgia, Stacey Abrams, who's Black. It ends with Nina Perales, who's Latina. And I wanted the book to arc from the people who were famous and who were, third generation lawyer in Yates's case, to people who really came up thinking, I can't believe I got a law degree. That arc felt really important to me. But also I wanted to start with, as you said, an institutionalist, somebody who you hear her talk, it's like a Frank Capra character. She really believes in an independent Justice Department. She really believes that the post-Watergate reforms that were put in place so that the president couldn't unduly influence the Attorney General, that stuff really matters to her. And as you trace the book, a lot of the lawyers I interview don't feel that way, both about institutions and the rule of law. They're much more ambivalent. But I wanted to start with Sally Yates, both because we all remember that moment. It was an extraordinary moment of standing up to something that was lawless. As you say, we didn't get enough of those. I'm not sure we get a lot more of them. I think we get sort of the Cassidy Hutchinson version of that now, but not the, I absolutely thought it was wrong at the time, and I said so, and I took my lumps. And I think also I wanted to hold her out as somebody who really, really deeply believes that the rule of law is this magical, divine thing, because an awful lot of the folks that I interviewed later in the book feel very much not that way at all.
I want to turn to Charlottesville, and rather than for this chapter talk about Robbie Kaplan, who was a hero and sued and helped to bankrupt some of these white supremacists, I want to talk about you because you were living in Charlottesville at the time. For everyone who says, it could never happen here, you were the person seeing the tiki torches in your town. And I just want you to reflect a little bit on both the reemergence of anti-Semitism in the United States and the responses in law to that, and whether law is up to the task of dealing with what we're seeing on the left and the right, in their extremes.
So I think that Charlottesville, in many ways, different chapters of this book, which at one level feel like their history, right? Bridget Amiri is fighting for abortion rights for migrant teens at the border. Becca Heller is fighting for refugees to be able to lawfully enter the country when they have the documents that should allow it. So there's a way in which I wanted to capture history, but there's also a way in which, as you say, some of this stuff keeps repeating itself. And if you lived through Charlottesville 2017, January 6th was not hugely surprising, I say with some regret. Both of my sons, who were 12 and 14 when Charlottesville happened, both took January 16th as Groundhog Day. Failures of policing, ample warning, clear that they were coming to commit violence and mayhem with a massive racial and anti-Semitic tinge, and yet it happened. And so for me, Charlottesville is very much a harbinger, as you say, of what was to come, what is still coming. In Charlottesville, you're right, it was very personal. I had lived there for 18 years. That synagogue, the one, sort of main non-denominational synagogue that's, reform services on Friday night and conservative services on Saturday morning, is where my children had their bris. They hate when I say that. It's really like, that was my community. And the other thing I would say is that Charlottesville doesn't begin and end in August of 2017, because we had a Klan march, we had another white supremacist torch march that spring, we had another Proud Boys march. So it was all coming. And the fact that the city was not prepared and the National Guard was not prepared, the governor was not prepared, was another example of the failures, as you're saying, of structures that we, I think, particularly as Jews, took for granted would show up for us, failed to, right? And I think that has to be reckoned with on its own terms. Part of the reason that I tell the story of Robbie Kaplan and Karen Dunn is that they do this version of, I guess, if the Jeff Sessions Justice Department isn't going to investigate this as an act of racial hatred that is deliberately being done to incite racial violence, and it's not going to be done in any other context, and Donald Trump is still saying there are very fine people on both sides, then somebody had better step in. And so the two of them, as you say, bring this amazing, Reconstruction era KKK Act claim, a civil action against 36 of the, various white supremacist, Nazi, KKK adjacent groups and their leaders and some of the ringleaders. And it's a really interesting story, both because they file in the fall of 2017, and the case doesn't actually go to trial until 1 year ago, November of 2021. So justice is slow. But as you say, they got $26 million in damages from all these various groups that they may or may not collect. But the important thing is the very last piece of your question, which is, what does the rule of law do to vindicate that? And I think it does everything. I think it creates a record. I think it puts these guys on notice that they can say that it's just speech and it's all fun and they're protected because this is just like Skokie, and how dare they be punished for their, admittedly cheeky but not dangerous speech. And to have, I think, Robbie and Karen come down like a hammer, and to have a jury say, no, this crosses the line from speech into violence and incitement of violence that leads, by the way, to the death of Heather Heyer and the maiming and injury of others, including UVA students. I think it's essential that the rule of law does the work of creating a record. And I would maybe reflect, in addition to that, as somebody who covered that trial last year, I was astonished that it wasn't talked about from every pulpit in every synagogue around the country. I was astonished that it wasn't on the front page of every Jewish newspaper. This is what the rule of law can do. And it almost went so completely under the radar that we don't think of it as a victory, when in fact, I think it was one of the most consequential victories of the last 6 years.
Yeah, and it's coming. I mean, today we just read about $1 billion verdict against Alex Jones. I mean, so not that it'll be collected, but there is this public aspect of vindicating people's rights that still exists for now. Lady Justice is the book. One of the things that you and I know, both as authors, is that there's a long lag time between the time you finish the manuscript and the time it actually appears in print. And some stuff happened with abortion as your book was closing. And, if you could expand what you said in there today, are you surprised that, I guess your book closed just as Dobbs comes out. Are you surprised that there are not marches in the streets every day?
I am and I'm not. And here is where I think I land on this, although it's troubling. I felt, and I know you and I talked about this last year, that after SB 8 in Texas, which was the so-called vigilante bill that allowed people, anyone in the country, to collect a bounty if they could sue somebody who either, provided an abortion or aided and abetted an abortion, right? And the Supreme Court allowed that to go into law a year ago on the shadow docket, right? On the emergency docket without real reasoning, without explaining. And I thought people would be on the streets about that, right? The Supreme Court had just allowed the state of Texas to nullify Roe v. Wade flagrantly, deliberately. And we all just went, oh, that seems a little weird. And we moved on. And then we heard oral argument in Dobbs. It was, I think, abundantly clear for those of us who were listening that the court was going to overturn Roe. Whether they were going to do it big or small, I think was a question. Although not really, if you listen to oral argument, it was clear John Roberts had no votes for his notion of doing this narrowly, just upholding the Mississippi ban, but not overturning Roe. And that's what happened. Then we had a leak. So at that point, we had our third warning that this was coming. So by the time the Dobbs opinion finally comes down in June, I sensed somewhat that the fact that people were shocked was a function of just not paying a ton of attention to what the track was clearly leading to. And I don't say that with any joy or any schadenfreude. I just think that the cards were on the table all year. So then the better question is, why was it that so many people who, heard Brett Kavanaugh and heard Amy Coney Barrett and heard Neil Gorsuch were tapped expressly for the purpose of overturning Roe, who knew that Donald Trump said, I'm only going to put people on the court who are going to overturn Roe, were shocked and surprised that they weren't sort of centrist moderates the way some of the media had portrayed them to be. And so I think part of that is a media failure, and we can talk about that. But part of it, I think, is that we are, and I know this is with the exception of an awful lot of people who are watching this who know better, but I think we just kind of hit screen save after the Warren Court. I think we all just said, oh, cool, equality is nigh. Women are 50% of the law school classes. Women are, in the courts. Women are governors and secretaries of state. So it must clearly be the case that we are inches from equality and perfect parity, and this can never happen. And I don't think it's unreasonable to think that, because all of those markers of equality were there. And yet Dobbs kind of proved that it doesn't matter. And so I had to, as you say, massively rewrite the introduction, the epilogue, the chapter on abortion in just a few days after Dobbs came down. But for me, it becomes where the book swings from being a book about history of, 4 years of the Trump era to a book about women and power in the law. And in some sense, the book seeks to be a little bit of a blueprint, as you said, for how we move forward in times of lawlessness. But I also wanted to surface for me what is this deep anxiety that I feel among women who think about this sort of split screen of, simultaneously thinking, we're good, the law makes us equal, it gives us dignity, it gives us equality, it's why we have credit cards, it's why I didn't have to hide my pregnancy at work the way RBG did, when she was at Rutgers. And that's true. But the law is also the instrument that has held women down, has put women in jail, has, thank you, Sir Matthew Hale, cited with approval in the Dobbs opinion, had women burned as witches. So I think that we just live on that very uncomfortable seam between, and if you are Black in America, you also live on this seam, that the law is meant to be the thing that makes you free and gives you equality and gives you dignity. And formally, that's true. The law is also the thing that means that if the police pull you over, you are more likely to be shot. And so I think that this book really is trying to grapple in a deep, problematic way with what it is that the law is both. And here I'm going to just quote Homer Simpson, who says of beer, I once told this to Anthony Kennedy, thinking it would get into an opinion, it did not. Homer Simpson says of beer, it is the cause of and solution to all of our problems. And that is what I'm kind of positing here, that the law is for women. So I think that the law is the thing that has made us free, that has allowed me, to vote and allowed me to go to law school and allowed me to have a profession and to earn something close to, what a man earns. And that's all good. But the law is also the reason that women are in jail in Alabama today, because the state thinks they're endangering their pregnancies. The law is the reason that Brittany Pula is in jail in Oklahoma for a miscarriage that the state deems was the product of drug abuse. And so I think we just have to sit in that tension of the law as the instrument of our freedom and our oppression. And for me, Dobbs really lifts that up. And it lifts up the possibility that the thing that we entered the term last year thinking made us free and equal is the thing that is going to put women in jail for miscarriages. And how we think through that, I think, is one of the fundamental themes of this book and one of the problems I'm clearly struggling with myself.
Well, you talk about the judiciary and women. Let me talk about it more directly. And your couple of chapters on MeToo, and specifically Judge Alex Kaczynski, the former Ninth Circuit judge who resigned, I would say in disgrace. I don't know how he felt about it when he was faced with multiple credible allegations of sexual harassment from many women, including you and including some of our other good friends. You talk about how everyone knew or sort of knew or winked and nodded, but there were no consequences. When he resigned from office, the judicial investigation ended. Clarence Thomas, there was no real investigation of the Anita Hill allegations. We know the FBI didn't really handle the Christine Blasey Ford and other allegations against Justice Kavanaugh in any serious way. Does the judiciary have a specific problem, or is it just this is where we're shining the flashlight and the problem's everywhere? It's no worse than the judiciary, and they're getting their act together.
I mean, the Me Too chapters are personal for reasons that you just explained, and I'm just going to flag again that Rick Hasen was the person who, for several people who had made allegations against Judge Kaczynski specifically, Rick came forward and said, that's something I saw. And again, there should be tens and thousands of you, and I'm grateful. I think on this question of the law itself, look, I mean, Me Too was happening all around the country in other contexts, right? It was happening in journalism, it was happening in Hollywood. So I was, of course, in my lane, watching it unfold in the judiciary. And in some ways it's no different, and in some ways it's profoundly different. And the first way is, first and foremost, we task the Article 3 judiciary with investigating and determining facts about allegations that are contested. So if the judiciary cannot do the work of figuring out if a person did or didn't do that which is alleged, that's problematic. That's their job, right? And that makes it different from Hollywood. But more to the point, those same judges are the one who will then sit in judgment on other, right, cases about sexual harassment, sexual violence. So to me, it's much worse that it's happening in the judiciary, both because I would like to believe the judiciary is competent at fact-finding and at making conclusions of law, apparently not in some cases, but B, because the judges that continue to sit on those cases are hugely problematic. And that goes, in my view, to, you know, questions I have about how it is that both Brett Kavanaugh and Clarence Thomas can sit dispassionately on the Supreme Court when these issues come up. So that's the first thing. Maybe the coda to that is, and anybody here on this conversation who hasn't experienced a federal judicial clerkship is going to think what I'm about to say is bizarre, but here it is. This is the only profession in the world that is still doing apprenticeships the way they were done 200 years ago. And what that means is that when you clerk for a quote unquote feeder judge, you are now vaulted into the world of Supreme Court clerkships. That gives you this crazy, like, tens and thousands, hundreds and thousands of dollars of signing bonuses. You're now in the catbird seat for the rest of your life. And right or wrong, law students who will fight about which color highlighter they use will certainly say, I guess it's worth it to clerk for a feeder judge, even if they abuse me, even though everybody knows they're abusive, even though they show me porn, which was the allegation in the Kaczynski cases. It doesn't matter because I'm still going to get a Kennedy clerkship or an O'Connor clerkship at the other end. So I think that part of the problem is that the federal judiciary, which tends to say, my clerks are my family, what happens in chambers stays in chambers, everything has to be secret, there's no reporting mechanism, there's no formal way to adjudicate this, is insane. And the fact that law students are complicit in that is also insane. There's a simple fix for this. Don't clerk for people who are known to be abusive. But I just think in a deep way, The judiciary has tried in sort of greater and lesser ways to address some of the claims that came up around the MeToo stuff. But I also think the fact that federal judges still make claims about, oh, we're just family and I treat my clerks like my children and they're supposed to keep secrets because that's how family works. Like, hello, Tolstoy, that's not how a place of business should work. And unhappy families are unhappy in ways that are profoundly dangerous. And by the way, I want to say one tiny other thing, which is the MeToo stories tended to center law clerks. They tended to be white and very powerful, but the people who really do get abused sometimes in the judiciary are, the marshals, the bailiffs, the cleaners, and those people don't get to surface their stories. So I think this is, as you said, something that would have been massively, massively helped, both in Kaczynski's case, but also I think in the Kavanaugh and Thomas case, from having a meaningful adjudication of facts and allegations, which didn't happen. And I think it would have been not just better for the complainants, but for the people who were the subjects. Because I think that the failure of MeToo and the failure to have meaningful process and conclusions means that everything turns into which side do you believe, which mob do you run with? And that is antithetical, I think, to doing justice.
So we're going to turn to questions in a minute. And I've got more, but I'm running out of time. So your book ends on voting. And so rather than ask you the question about Stacey Abrams' complicated legacy, and you and I have discussed this on your podcast before, and her claims about the last election not being legitimate and whether that was a precursor of Trump, I want to focus on something a little more uplifting, which is your chapter on Nina Perales, who's one of my personal heroes. She's a lawyer for MALDEF, which is the Mexican-American Legal Defense and Education Fund, litigates voting rights and redistricting cases. And I guess the question, since you've interviewed her and spent time with her, is what makes her go on? Where is the source of resilience? Because as you and I have talked about many times, the judiciary is not the friendliest place for minority voting rights plaintiffs. How does she do it?
And parenthetically, I would add, she's a woman in a very male-dominated field. I mean, gerrymandering and redistricting and apportionment and this census litigation, this is pretty alpha male territory. And so she's also an outlier in that sense. And, maybe, Rick, this goes to that big welcome to my breakdown theme of, is the rule of law getting us there, or is it in fact hampering us? She is such an effusive believer that we are getting there, that the arc of the moral universe, fits and starts, ebbs and flows, pendulum, but that we are getting there. And she really did say several times when I interviewed her, judges want to do the right thing. They want to have, it's hard to understand. It's particularly hard when you have to make a showing that is almost impossible to make under current doctrine. But I think she just felt like, and part of me was like, come on, what's going, I want what you're having. But I really think she believes that the nature of a sort of pluralistic liberal democracy is that people get it. People are getting it, and that they want, by and large, outcomes that are fair. They believe in their bones in one person, one vote. They believe in their bones that this is a country that is at its strongest, as she said, when we value immigrants, when we value people who aren't white. And, she makes this kind of argument using demographics. Obviously, she's thinking about Texas and how Texas is changing. But I love that she also has such a deep solicitude for the ability to know what you don't know and to learn what you don't know. And that she describes, when you go to a judge and you just show them, like, this is what needs to happen, that more often than not, they come along. And I think I always am mindful. I'll just end with this because it makes me happy. One of RBG's favorite stories, and I know we're not doing RBG hagiography, but let's just do a glimmer, is that at the very end of his career, then Chief Justice William Rehnquist writes this incredible opinion in this Family Medical Leave Act case, right? And this is a guy who has not been a reliable progressive, to say the least. But he writes this opinion through the lens of having watched his own daughter trying to be a single mom and juggling childcare and like dumping the kids at his chambers. And suddenly it's like, oh my God, it's really hard for women who are burdened with caring for people and doing all this stuff. And RBG used to tell the story of how Marty, when he read the draft opinion, I'm not going to do a very good Marty Ginsburg, but apparently he said to her, Ruthie, did you write this for him? Like, thought she'd ghost written this opinion because it was so tender about the lived lives of women and people who are caregivers. And she always told the story to kind of make the point that, you know, feminism and understanding that you don't know what life is like until you've kind of walked in someone else's shoes, all that stuff is contagious. And I love that story because to me, she used to tell it as a kind of a, and we got another one. And I think her life work really was trying to explain, usually to panels of white men, what it was like to be a woman and how that was tricky. And I look at Nina and I think she's doing exactly the same thing. She's talking to panels of judges about what it is to try to be an other in this country who just wants to be seen in democracy. And I love that because I think the line between those two kind of projects is actually very short. And it's a line that I think we all have to kind of get involved in, helping lift up, you know, those stories of this is a thing you don't know, and this is the thing that the law should reckon with.
So we have a little bit of time for some audience questions. And let me start with Deborah, who asks, who do you think leaked the Dobbs decision and why did they leak it?
I think the why is pretty straightforward at this point. And I think that it's fairly evident. This is not unlike the leak in the Obamacare case that was leaked, I think, to try to shame John Roberts. You know, there was a leak then that was an attempt to say, you know, John Roberts has gone squishy and he's going to flip and vote with the liberals. And it was an attempt to sort of stiffen his spine. This feels a lot like that. It feels like a leak that was done because there was a lot of feeling that maybe Brett Kavanaugh or maybe Amy Coney Barrett, who seemed at oral argument to be on the team of the 5 justices who were willing to overturn Roe, but had concerns, particularly Kavanaugh had concerns. So this was a way of saying, you know, we did the straw vote. It's going to be 6-3 or 5-4, depending on how you count. And we're not going to let Kavanaugh and Barrett go squishy. And that appeared to be the purpose of it. You know, I know there was a theory that one of the liberal justices leaked it to try to shame them into flipping. I don't know that that shaming is a big mover of votes. So I think it's probably the former. I'm curious, Rick, if you think that's different. As to who did it, it's, you know, very, very hard to know. I'm pretty confident that this crack investigation that's being done that has still turned up nothing will continue to turn up nothing. The court certainly had the option to bring in a meaningful investigating entity and chose not to, chose to do it in-house. But I think that it's, my guess is more likely than not just somebody who picked it up off a printer or some, you know, clerk who saw something lying around. I think it was more purposive than that. I don't think leaks like that happen at this court. And as to who did it, you know, my guess is it's somebody who was in the majority who essentially wanted Barrett and Kavanaugh to be locked in, but I don't know beyond that who I think it was or whether it was authorized through a clerk or a justice themselves. Rick, do you disagree with anything I just said?
No, I think it came, and that was my first inclination when I saw it, that this was, you know, this is an attempt to distract from what the ultimate opinion was going to be, soften public opinion, and to shore up the majority. And in terms of who it could be, it's hard to know. It could rhyme with Shinny Lamas. I don't know. I mean, you never know who it could be. Staying on Dobbs, Susan asks, will Dobbs lead to the unraveling of same-sex marriage?
I mean, Clarence Thomas says so explicitly in his concurrence, right? He explicitly says all this other stuff that is under the substantive due process, you know, these privacy rights that are unenumerated, and therefore who knows what they mean, is all on the table. And I do think that if you look at the reasoning in Dobbs, the tell that Justice Alito puts in his opinion is like, oh, don't worry about that stuff, but I'm not going to tell you why, is a reason to worry. I think, when they say, oh, this is not on the table, it probably means it's on the table. I think that there's no question that there are some votes. I don't think there are 5 or 6 votes to go after Obergefell, in the near future. I think that there is not, I think, the same appetite for that. But I do think that doctrinally, if you start pulling out the sort of Jenga piece that is, there's no such thing as substantive due process, and all of these unenumerated rights in the Constitution are, made of whipped cream, then it's very, very hard to say why Obergefell is different. And I think that we're going to probably see it go the other way, which is to say, I think we're going to go from Dobbs to personhood. I think the court just rejected this week a chance to, find constitutional personhood. But I think it was a crazy case, and it was a way too big a swing. But I do think that birth control, in some sense, falls apart for the same reasons that Dobbs falls apart. And so the better question is not doctrinally whether Obergefell is sound in a way that, Dobbs is not sound, or Griswold is not sound, or Loving versus Virginia is not sound. All of those cases are rooted in the same doctrine. The question is whether the court has an appetite to go after those things, and when. And maybe this is the thing I'm going to say that is slightly hopeless. And I think I said it in a conversation with Rick a few weeks ago, teeing up the term. I don't think this court has a braking mechanism at present. I have no reason to believe that the court has any interest in doing what it did for the 22 years I covered it, which is we'll go big with 2 cases, but small with some others. We'll only grant cert on a handful of cases and leave the others for next term. If we go big in something, we'll pretend it's small. All of the tricks and machinations that used to be used to say there's nothing to see here, as best as I can tell, are gone. And so what worries me most, both about last term and this term, is that we're talking about the term as cases. Oh, affirmative action is coming up. Racial gerrymandering is coming up. Independent state legislative theory is coming up. And we shouldn't be talking about cases. We should be talking about how the court is doing business. And I think we in the Supreme Court Press Corps have done a less than excellent job of talking in terms of lines of doctrine, like the one we've just talked about, and how that's vulnerable, as opposed to these are the cases we're looking at this term.
Yeah, I mean, I think the Supreme Court Press Corps, you kind of get your curtain raiser in late September, early October, you get your July wrap up big term, but it doesn't happen during the year. It's much more of here's what happened Tuesday.
Right. And here's what happened to doctrine, as though doctrine is still a thing. And if you look at the end of last term, I guess there's now a major questions doctrine. I don't know what it is. I guess there's new law around church state and prayer in public schools, but I don't know what it is. There's new school funding doctrine, but I don't know what it is. And so I think we pretend like, oh, there's a test. Here's the test. It has 4 prongs, except it's not the test anymore. We just don't know what the test is. And I know we're not supposed to be like ending on a bummer note, but I think one of the things that happens when you hyper focus on doctrine is it's a way of kind of performing that this stuff. But it's not a really good way of saying what just happened. Like doctrine is a smoldering ash heap after the EPA case last year, after the religion cases, certainly after Bruin, the guns case. None of us really knows what the new test is. The test is the court arrogating unto itself the power to decide what the new test is. And so I think that there's something just way too blinkered and narrow about focusing on doctrine as though that's the thing that's changing here.
Well, since we are running out of time, I'm going to combine a few questions. Deborah asks, what do you think will be the impact of Justice Brown Jackson? And a few viewers ask, what about the subhead in this great book, the battle to save America. So here's the combination question. I listened to Justice Jackson, so formidable right out of the box in a voting rights case that was argued last week out of Alabama. I mean, she just took charge. There was none of this kind of tentativeness or timidity that you often see with justices. Is she going to be the next hero in the second edition of Lady Justice? Is she, someone we're looking for in the battle to save America, or is this the kind of hero worship that I've condemned for a long time about Justice Ginsburg and you mentioned? Should we have faith there?
I think that what Justice Jackson did last week, and for folks who haven't listened to the audio, it is, as Rick just said, it is formidable to hear someone descended from slaves on both sides, right? Reading the actual reports from the drafting of the 14th Amendment in order to make the point that, oh, if you're going to do text and history, if that is in fact the conservative movement's legal project, here's a little text in history. And by the way, the 14th Amendment was not race blind or race neutral. It was intended to remediate something very specific, which is racial injustice. And hearing that, I mean, it was the first time that I thought, oh, I bet John Roberts is a little sorry that we can all listen in on C-SPAN. I mean, the court made the decision this year, even though that they were back in person, to continue to allow us to listen to same-day audio. And it was profound to hear someone saying, here is what radical abolitionists were trying to do with the Reconstruction Amendments. And so I think that matters. And I think she's going to locate herself in the place where Sonia Sotomayor has been for some time, right? I think Justice Kagan has been more apt to be a little bit careful and a little bit trying to get to yes, although more and more, particularly, as you know, Rick, in the voting rights cases, not very much a shrinking violent. But I think I also would say that Justice Sotomayor has been a clarion voice for the thing I was describing RBG doing with Rehnquist, which is, here's the thing you don't know about, race, about policing, about incarceration, about the death penalty. And I think that Justice Jackson is going to put herself kind of in that camp. And I think it's useful to remember, I was telling some very hopeless law students yesterday that dissents are really powerful, right? Like, read the dissent in Korematsu, read the dissents. I mean, dissents are kind of love letters to the future. They're a way of saying, this is what we need to be. We need to do better. And Justice Scalia used to always say, I don't write dissents for my colleagues. They're boneheads. That's me paraphrasing. I don't write dissents for my colleagues. I write for the law students. And I think that that's what Justice Jackson will do. And I think it must be terrible to know you're going to be in a minority of three. And by the way, 3 women. It's very, very challenging to think of where you accrue power from that. But it is very clear that Justice Jackson is not going to go softly through that she is going to use this tremendous brain and, as you say, formidable rhetorical skills to make, not just to say I'm giving voice to people who are invisible to the majority, but I think to make these incredible arguments about text and history, the conservative legal movement's lodestar, and to do that in a way from the bench, it is incredibly important, even though maybe in the near term, it's not going to pick off any votes.
Well, we've reached the end. The book is Lady Justice, Women, the Law, and the Battle to Save America. Dahlia, I'm supposed to give you 2 minutes to say something positive. We could just end right here, or you could take that opportunity.
I mean, I think, like, let's look at Alex Jones, as you said. Let's look at another court enjoining an abortion rule today. Let's look at the women in Kansas who lifted up the sky and protected abortion rights, the women in Michigan. I think the positive thing that I want to leave people with, and this is very much, I think, the engine of the book, is that all too often we are told, we're using our voices, we're protesting, we're out on the streets. But we have this amazing toolkit called the rule of law, and we know how to blue book, and we have yellow pads, and we're in courts, and we win a lot. Donald Trump lost a lot. And I think to really be mindful of the ways in which, yes, The legal system is maddening. It is slow. We suffer setbacks as we did in Dobbs, but the next day, amazing women were in courts all around the country, and men, filing petitions and winning. And so I just think this is depressing, but I think that there is no alternative to the rule of law. It is street fighting, and I'm bad at it. So I think that we have to fight for this very complicated, maddening thing that is slow and that sometimes fails us, but that women are, I guess this is my shirt. Somebody said, what does your shirt say? Women plus law equals magic. I really do think that we're actually very, very good at this thing. And that given the opportunity and the time and the support and the visibility, which is what I wanted this book to do, I think we could change the world still.
Well, that's pretty uplifting. Next time you'll talk to me about voting rights and we'll get back to that right level of gloom and doom. Thank you for all that you do, not only to write about these important issues, but to write about them in a way that's accessible. I mean, one of the real things that I think the legal profession does a terrible job at is communicating more broadly as to what the principles are and how things work. And it's so important. Law is too important to leave to the lawyers. And I think you are at the forefront of being that explainer, and I'd put you in my book of heroes. So thank you, Dahlia. I want to just take a minute and remind the audience of next week's program. That will be with the author of another New York Times bestseller, Peter Baker, and Susan Geller of The New Yorker. They'll discuss their recently published book, The Divider, Trump in the White House, 2017 to 2021. They'll be interviewed by KCRW's Madeline Brand. That's going to be next week, Wednesday, October 19th at 5 o'clock Pacific. Thanks to all of you for joining us. I wish you good health and safety. Take care. Thank you, Dahlia.